So at this time, I would like to introduce Trent Dougherty. He's Director of Legal Affairs for Ohio Environmental Council. He's come up today from Columbus to tell us more about the specifics associated with the constitutional amendment and what we're planning to do with the Ohio Department of Natural Resources and the Ohio Inspectors General. Trent?
Thanks, Paul. Hello, everyone. I am Trent Dougherty, Director of Legal Affairs for the Ohio Environmental Council. The Ohio Environmental Council, for folks who don't know us, we're a nonprofit environmental conservation advocacy organization. About 110 organizational groups, ranging from sportsmen's organizations like the Isaac Walton League of Ohio and the League of Ohio Sportsmen to Friends of the River organizations, as well as a few thousand members across the state of Ohio. And as Paul said, we're here to talk about water especially. Water is the basis for all life, and in much of Ohio, groundwater and surface water is extremely important to the value of property, whether it be a small domestic well or to a large series of springs that feeds a large dairy or cattle operation. A landowner's water supply is important to sustain not only human existence, but economic existence as well. An overwhelming number of Ohioans, as Paul said, confirmed this sentiment 2 years ago in passing an amendment to the Ohio Constitution's Bill of Rights, giving each landowner a property right in the reasonable use of groundwater and surface water on their property. However, over the past 2 years, Ohio's administrative agencies have done nothing to alter their policies to ensure protection of landowners in Ohio. In particular, Ohio's procedure for requiring coal companies to replace water where coal companies and mining operations have dewatered or seriously diminished water supplies, and only allowing the coal companies to hook landowners up to public water supply and then pay them a lump sum, the equivalent of 20 years worth of water bills. Coal companies further have used this policy of 20 years and a 20-year lump sum as a sword to force landowners to negotiate for much less than their water rights are really worth. ODNR's permitting of industrial activities that diminish or sometimes completely dewater a landowner's water supply without full and proper compensation is, in my legal opinion, an unconstitutional taking of that property right, and not just for a public use, but for a private entity's use. Further, ODNR's procedure allowing compensation to be limited to 20 years worth of water puts landowners at a distinct disadvantage against coal companies and their $600 an hour attorneys that are negotiating for water replacement. And as Paul said, while we're here in Carroll County to discuss the impacts of a 30,000-acre underground mining operation, this isn't just a Carroll County issue. This isn't just an issue with this large-scale room and pillar type mining. It's longwall mining in Belmont County. It's surface mining in Perry County that we've dealt with landowners with on this issue. And it's not just coal mining. It's other extractive industries that ODNR permits, such as oil and gas drilling and industrial minerals mining. And it's not only ODNR that is the one permitting this. This also deals with Ohio EPA's permitting of various types of landfills, whether it be construction demolition debris or municipal solid waste landfills. The Department of Agriculture's siting and permitting of large-scale livestock facilities. So that is why next week, Ohio Environmental Council, along with landowners, are filing a letter with the Ohio Inspector General, urging the Inspector General's office to initiate a full investigation of Ohio state agencies that permit, oversee, and conduct activities that interfere or have a high likelihood of interfering with Ohio landowners' property interests in the reasonable use of their water. State agencies who have for years permitted these industries to take water from neighboring landowners could be faced with a barrage of takings claims. A single water consumption permit that dewaters an aquifer or a stream could impact many landowners. Such a multi-plaintiff taking case before the Ohio Supreme Court could trigger a compensation order that would make the famed RTG coal case. This is a case from a few years ago where the Ohio Department of Natural Resources had to pay a coal company approximately $5 million because of the decision by ODNR to take a portion of Pleasant City and make it unsuitable for mining. So that $5 million takings claim very well could look like a traffic ticket compared to what is out there when you're dealing with takings claims, dealing with water rights from thousands and millions of landowners. And as Ohio's chief watchdog, it's the purview of the Office of the Inspector General to investigate the management and operation of state agencies on his own initiative in order to determine whether wrongful acts and omissions have been committed or being committed by state offices and state officials. Further, we call on the members of the General Assembly, and especially the Ohio State Senate, who have clamored and fought for the concept of regulatory reform, to reform regulations to make the state of Ohio more business friendly. And we urge them to first reform regulations to protect Ohio landowners' rights, and especially those members of the state Senate that sponsored and co-sponsored the Senate resolution back in 2008 that put this water rights amendment on the ballot. They should be the very first ones to step up for landowners, not only here in Carroll County, not only those dealing with water loss from coal mining, but from any extractive industry or anything which Ohio agencies permit that take water and not compensate for that water loss fully and completely. And also, Governor-elect Kasich and the incoming administration need to make protecting Ohioans' private property rights a priority. The governor-elect was recently quoted as saying, "If you're not on the bus, we're going to run you over with the bus." I just urge you, Governor-elect Kasich, that you need to make room on that bus, seats on that bus, for landowners in the state of Ohio to protect their rights. These rights have been run over for way too long, and it's time that the state agencies and the General Assembly stand up for these people, landowners in Ohio, and actually protect their rights.